Good morning. Are you Reagan Howard?
Yes, ma'am.
And this is 22-39924. And give me just a second. Miss Howard is on probation for deadly conduct, discharging a firearm. A motion to revoke that probation has been filed. There is not a bond at this time. There's been a motion asking that I set a bond. And Mr. Kimler, do you wish to call any witnesses with
Ms.
regard?
Howard, Your Honor.
Ms. Howard, the best you can, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this case or hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
May I proceed, Your Honor?
Yes.
Ms. Howard, you understand you're on deferred adjudicated probation for third-degree felony offense of deadly conduct, is that correct?
Yes, sir.
You understand that that's punishable up to 2 years, or from 2 years up to 10 years in the penitentiary?
Yes, sir.
And a motion to revoke probation has been filed asking that the judge revoke your probation and sentence you within that range.
Yes, sir.
Are you requesting that pending a disposition of that determination, that the judge admit you to a bond or provide a bond in the case so you could get out and attempt to resolve some of the issues that you're having on probation?
Yes, sir.
If the judge were to give you a bond in this case, where would you reside?
1950 Poplar Street,
In which city?
Beaumont, Texas.
And would you report to probation as instructed?
Yes, sir.
And do you have a job here, or what do you do?
No, not yet. I'm trying to get one.
Pass witness.
Any questions of this witness?
Ms. Howard, have you been using drugs?
No, sir. Well, I smoke weed.
Have you admitted to the probation officer last week in jail when she came
yes,
to
sir.
visit you that you have been taking?
Hang on, listen. Hold on. One person talk at a time. Let him ask the whole question, and then he'll let you answer it, okay? Don't start answering it while he's still talking, because the court reporter has to take everything down.
Yes, sir.
Okay.
So you have been smoking marijuana
Yes, sir.
and you haven't been reporting,
Yes, sir.
and you were ordered to go to ISF substance abuse and you refused to do that?
Yes, sir.
And we've offered again today and you refused to do that.
Yes, sir.
No further questions.
If I might, Chair, just to be clear, you haven't been smoking marijuana while in the jail.
Oh, no, not in jail.
This
No.
is,
No, while you're out on probation.
Yes, sir.
just wanted to clarify that.
So it looks like there was an administrative hearing back on October 1st of 2024. I'm just gonna, that was, so I guess I'm wondering, this administrative hearing recommended the ISF, right? Yeah, and JCDI, and there was a number of violations. But all of these violations, for some reason, were not included on the motion to revoke, because the second administrative hearing, I guess, that came through only had the kind of some new allegations.
Correct. So what happened was the first administrative hearing recommended ISF with JCDI's aftercare, and then when she never turned herself in, we asked for the ISF warrant to be rescinded and the motion to revoke to be filed instead.
So if nothing else, I think the motion, I would believe that the state might want to go back through that previous administrative hearing and allege all of those things in the motion instead of just the two new, because those are obviously fell under report, which is the same as the second administrative hearing, but there's tested positive for alcohol, tested positive for cocaine, tested positive for THC, hadn't done anger management, didn't do the substance abuse assessment, 2 different times. So, I mean, there's a lot more. If you just look at the motion right now, it only has 2 allegations, but it looks like it should have about 10 or 12 allegations. And based on all of those alleged issues, as well as the fact that Ms. Howard has just recently admitted that she was using drugs while on probation and not showing up, at a minimum, if I were to leave her on probation, she would be going to ISF or somewhere. So I'm not going to, I don't think it's in your best interest, Ms. Howard, that I let you out while this is waiting so you can go do more drugs and get in more trouble. It's obviously there's an issue that you have not been able to take care of on your own. So if you want to have any chance of remaining on probation, then that would be the only thing that I would consider doing. Otherwise, your probation is likely to be revoked if those things are found true, and you're going to go to prison for some amount of time. I don't know that that's where we need to get on this, but if I don't have any choices and you refuse to go get the help you need, then you're not going to give me any choice but to potentially revoke that probation. All right, so I'm going to, if there's some agreement that can be reached today, great. If not, I'm going to reset the case to I'm going to deny the motion for a bond. I think it is in the best interest of our community, and based on all of the factors in 17.15, the underlying offense being deadly conduct, the allegations of what has been and has not been taking place on probation, I am going to make the finding that it is best that a bond not be set at this time.
The state's offer was if she were to go to ISF, they would agree to continue her, or agree to recommend continuing on probation.
Well,
Ms. Harrison has,
I mean,
if she doesn't want to attend ISF.
If she doesn't want to do that, she doesn't want to do that. I'm going to reset the case. I would ask the state to make sure and go through the motion. If there needs to be an amended motion filed,
We'll be amending our motion
okay.
today or tomorrow.
Get that done quick. That way Mr. Kimler has all of that. We can come back at a later date, go through the motion, get pleas of true or not true, and then we'll go forward at that time.
Yes.
You can go back with the bailiff.
Can I say something?
Yes, ma'am.
Is it too much to sign up for ISF?
Talk to your lawyer about that. All right, are you Laddie Johnson?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Johnson, in cause number 24 DCCR 2388, the state has elected to proceed on count 1 only, and in that count to the lesser included offense of a Class A misdemeanor.
Here's the key moment. The state is proceeding on count 1 only, reducing the charge to a Class A misdemeanor for resisting arrest. This is a strategic move. It limits the risk for the defendant, while still holding him accountable. What do you think is pleading to a lesser charge smarter than going to trial? Or is it just a temporary win?
Misdemeanor resisting arrest, and that is from October 24th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen, sir?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Johnson's not competent?
No, Your Honor.
All right, Mr. Johnson, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of
The judge sentences Mr. Johnson to 200 days, giving him credit for time already served. Notice how he waived his right to appeal. That's huge. Shows the power of plea agreements and how defendants are trading some rights for certainty in sentencing. Would you take that deal, or fight for a trial and risk more time?
resisting arrest. Sentence you in accordance with that agreement to a term of 200 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Y'all have already got
Credit for time served.
the 200 days,
Yes, ma'am.
y'all have confirmed that. So it looks like you have 200 days credit, and so you should be, so you're getting 200 days and you have 200 days even.
Yes, 210 days, I think.
Okay. All right, so I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. Good luck to you, sir. You can go back with the bailiff. Good.